Well, good afternoon, everybody, and welcome to today's webinar, a webinar called Hanging Up Your Legal Boots. And my name is Sean Jardine. I'm a non-practicing solicitor. I think it's very important that the SRA know I have said those words, because apparently it means something when you retire from a law practice. But I retired from a law firm last year, and I'm now doing consulting for law firms, but I'm a non-practicing solicitor. My business is called the Big Yellow Penguin. Long story why that's the name, but one of the people who knows why that's the name is Viv Williams, because his was the first conference I ever stood up at dressed as a penguin to make a point. And you've only got to dress up as a penguin in London, Birmingham and Texas, and then funnily enough people seem to remember that you've done these things. And I'd like to introduce you to the panel that we've got, and at least on my screen it's going from left to right, a wonderful panel that I've managed to encourage, entice, blackmail to participate in this event. And we've got Tracy Calvert from Oakles Consultancy dealing with compliance issues. Say hello, Tracy.
Hello, everyone.
We have the one and only Mr. Viv Williams of Viv Williams Consultancy, who's been around the legal profession for over 20 years dealing with mergers, acquisitions, etc. Say hello, Viv.
Good afternoon.
And we have Jenny Screech from Howden's. You're going to detect an unusual accent, ladies and gentlemen. It's from down under, but not down under where you think, but down under nearby with a rugby team. Jenny, say hello from Howden's.
Good afternoon, everybody.
And we've got, with the check shirt there, we have got, do not adjust your, it's not a test card. He's doubling up as a test card. And if you're old enough to remember what a test card is, you're at the right kind of gig, I would have thought. We've got Andrew Allen from Francis Clark. Andrew, you're an accountant to many, many law firms, including my past one. So say hello, Andrew.
Good afternoon, everyone. Thank you. Yes, I do remember the test cards.
The thing is, you've got to be of an age now. I keep saying things and I get blank looks from people and I think they've got no idea what I'm on about. But there you go. But that's probably the story of my career. So how did we get into thinking about doing something about hanging up your legal boots? And really, one of the things that drove me to think, contact this wonderful panel that we've assembled is it's professional indemnity insurance renewal time. And that is something that I know prompts lots of smaller businesses, and indeed some of the bigger ones actually, to think, wow, that's gone up. What can we do? Should we be thinking about what our futures are? And then when you get into futures and exit strategies, sometimes the options are limited. And sometimes when we started out in the law, I was admitted in 1986. I thought, well, this is how I'm going to do, this is how I'm going to exit. Will it happen? Now, for me, luckily it did. I just retired and there was people who wanted to, buy my equity, pay out my capital account, and I retired. But for some people now, that's not the case. And what I have noticed when the delegates registered for this is there are some fantastic businesses out there in listening to this webinar, and congratulations to you. There were some really niche, interesting businesses. And when I saw you registered, on many of them, I had a look at the website and I thought these are great businesses, and certainly ones that you think there's got to be a future that is, where you can join other firms or whatever it is that you want to do as part of your succession strategy. But for some law firms, and we'll probably hear some stories from Viv and indeed Andrew, the future isn't so bright and the future isn't so rosy. So what I want to do over the next, 90 minutes max or so, if we finish earlier, we finish earlier, is to just kind of boot around some ideas. We talk about, some of the things that I think you've got to bear in mind. These were highlighted in the invitation. So this is going to be effectively I'm going to adopt the same running order and bash through these. But I don't know. Let's start off with Andrew and Viv then. Gents, what are the exit options that are available to law firm owners at the moment?
Who wants to go first? Do you want to go first, Viv?
I don't mind. I was going to say one of the things that I would encourage people to do is, well, two things really, is when you're thinking about succession, exit, and what options you've got, whatever you do, don't try and do it all by yourself. I've seen so many examples of law firms who've literally written to all their local firms saying, we're up for sale. And it's the biggest mistake they can make, because A, it makes them look weak and up for grabs for nothing. And secondly, people take advantage. I've been dealing with a commercial practice who have a good, successful commercial practice who decided they want to exit. And by trying to do it all themselves, they've discovered that nobody wants to buy their practice. So once you start looking into the detail of how we deal with the anatomy of a merger or a sale, it could be done differently. And the second thing I'd encourage people not to do is not to put your name on a list. Do not go with a broker that just lists 2 equity partner firm in, whatever it might be. People know who you are. So those are 2 fundamental things I'd say is get some professional help early. And I think that means talking to someone who understands what they're doing, to give you that advice and guidance. And that's what we do. I'm part of an organization called ALFMA, one of the founder members. ALFMA stands for the Association of Law Firm Merger Advisors. And what we try and help people to do is to decide what their strategy and succession plans are. So when we're looking at options, we find the best option for that firm. And there's a number in there. I mean, you could actually decide that the strategy could well be that we do need to find a third party to merge with. How do you go about that? Who do you approach? How can it be done confidentially to make sure you get the most benefit for the opportunity that's there with your practice? But maybe doing some work within the practice to start with is quite crucial before we actually get to the point of approaching potential buyers. So obviously we've got a sale to a third party merger. That's one option. What do you think, Andrew?
Yeah, I think possibly the one area I think always gets overlooked when people are thinking about succession is the most standard one, which is a normal succession. And whilst a lot of firms spend a lot of time thinking about how they're going to sell it, how they're going to merge, who they're going to find in that sense, actually spending some of that time making their own business better so it's more attractive to their internal people would be a good start. Yeah. Because that is, if your number one problem stroke challenge medium term is succession, that is your easiest outcome. Unless you're reasonably likely to be in line to get one of these golden tickets where you allegedly get loads of money for doing nothing and so giving your firm across, unless you really think you're in that camp, and there are a few firms that will be, but unless you're there, actually the easiest, probably most profitable way for you to exit would be a normal succession. Whether that means a repurchase of shares and passing on a company or normal partnership succession. So I think my starting point with a firm, if they've got enough time, and I think time's an important point in this, if they've got enough time, it's to focus on making themselves look attractive to their own people.
I think time is a really good point. And one of the things I will be asking the panel at the end is how much time they think they should start planning in advance of when they're thinking of actually wanting to exit the profession. I should have mentioned, part of my housekeeping, sorry, ladies and gentlemen, is if you want to type in any questions, please use the question and answer tab and type in a full question, and we'll get round to those if indeed time permits. But if we don't, then I will circulate the questions to them, because if they're obviously more for Jenny, more for Tracy, more for Viv or Andrew, or more for me, I'll find a home for you. So that's really interesting, Andrew, about the look at your own business to see if you can make it more attractive for people.
So, I mean, I guess, two really, for me, two important things in that I see is for incoming partners. I think there is, I don't know if it's a generational issue, which we could get into and probably make some inappropriate comments about, but there is less appetite in my general experience for people to want to buy in inverted commas, to law firms. And I say that in the context of when I first started doing this 25 years ago, you normally used to need to peel people off the ceiling if they'd been invited to become a partner. Whereas these days, you almost go into the room and need to convince them they want to do it. So very different mindset. And I think some of that is to do with demographics and social issues more than necessarily the law firms themselves. But the two things that repeatedly come up, which are a barrier to people joining firms, are obviously profitability. Another one, actually, I'll probably say with that is, if I just say duration of lockstep, and that can mean a lot of things, but basically how quick it takes their money and their income to go up once they become a member or an owner, whatever you want to call it. The other angle is how much they've got to find. And that is not just about whether they've got to write their own check, it's whether they've got to borrow money to join. So the other thing I would say, when I made the comment that people should look at their own internal performance first of all, that isn't just about PEP, that's about what their balance sheet looks like. So this might be relevant to, I don't know the mix of people on this call, but it sounds like it might be relevant to the audience, in that I've got a lot of clients I know that are hugely successful law firms, very profitable. And quite often, if I just take, let's say, a typical 3 to 5 partner firm, you will quite often find they've worked together for most of their working lives. They're very profitable. They have no debt on the balance sheet. They have no personal debt. Everything looks amazing. It's a very strong business to join. But as an incoming partner, if you're being asked to find $500,000 to join that business, which has no debt on the balance sheet, and it's an LLP and you're a bit risk averse, funnily enough, that's not distinctly appealing. So, that practices in that camp, for example, one of the things they probably should be thinking about in the run up to their succession is actually whether they need some debt in the balance sheet to make it easier for partners to come in. Now, that might seem completely counterintuitive to the people around that table, because they'll look at themselves and go, well, we're really successful, why do we need debt? And the point is, it's not for them, it's for the successor owners. And it's for the bank, so that don't immediately have a massive swing in your balance sheet when people join the firm. So there's lots of practical things that firms can do, but what they can't do is leave it until 6 months before they need 3 or 4 partners to join, and then start trying to put these fixes in place. So
yeah, and gents, what are the options that are available to a sole practitioner then? If we've got nobody that we can deal with in inverted commas for succession, what are the options for sole practitioner? They're presumably limited.
Well, very limited. And I think the problem is very few people at the moment want to become a successor practice. And of course, if you acquire a sole practitioner, you automatically become a successor practice. So part of the challenges, I think, for a sole practitioner is to find someone where they can merge their practice into someone else. But some of them, unfortunately, are, I know it's not a fair word, but unmergeable. Some of them, no one wants to become a successor practice to someone who's got a bad claims history, for example. So I think it's understanding what the business is and what it's done. I think it's quite difficult for those type of firms to find a way forward. I mean, I'm dealing with a firm currently, and it's a historic problem, but I think it's relevant to this. Not a sole practitioner, but a 2 equity partner firm. It was a 3 partner firm 3 years ago. One of the partners turned out a bit rogue and was obviously they had a number of claims hitting their policy. Their premium in 3 years has gone from 50,000 on a 500,000 turnover to 100,000 this year. As of the 1st of October, their renewal stands at 184,000. Now, these 2 boys are in their 70s, and you think to yourself, how do you close your practice down from that point? So they're making some really tough decisions about taking some insolvency advice about what they can do, what they can't do, and really understanding what their options are. Because think about the runoff situation. If they paid runoff today, let's assume it's 3 times their annual premium, that would be somewhere between 300, 350,000. If their annual premium is 184,000, we're talking about nearly 600,000 for runoff, which is more than their turnover. So there are some real challenges out there. And that's just one example that people, unfortunately, circumstances have brought them to a point where they can't cope with their runoff. So I suspect they'll probably go through an automated closure, a PVA of some sort, and maybe they'll have to look at personal debt situations themselves. So it's that type of scenario in the wrong circumstances. So the best way is to plan early and find someone who wants to take over your niche, your specialism, whatever that might be.
And Viv, you'll know that I'm acting for a client that wants to buy will banks and things like that and turn those into some kind of annuity. Is selling the assets that some of these sole practitioners may have, that might be an option to get rid of the will bank to someone that can create an annuity?
Absolutely. And I think that's a good option for some people. It may be their only option.
Yeah.
So the will bank may be, let's say they've got 5,000 wills built up over the last 30 years or so. That will bank will have a value, but only to someone who can actually farm it, cleanse the data, actually talk to the people. And we know these will specialists can actually upgrade wills, lasting powers of attorney, trusts. So they may be getting £1,000, £1,500 for every transaction they create, not just the will itself. And the annuity model works on a percentage of what's generated over a period of time. But that value could be placed individually as a sole practitioner.
And just for the sake of completeness, I would be remiss of us not to talk about employee share ownership schemes. I know that a few of them happen, but are they still, could we count them on the fingers of two hands? Andrew, have you come across many of these?
In various forms, yes. I was just about to comment on those, and perhaps not in the Viv mentioned a fairly extreme case there, but I agree with his comment. Sole practitioner limited companies, sole shareholder companies are probably some of the more problematic ones to deal with. And I would say perhaps those are the ones that do fit an employee ownership trust model a bit better, because I'm not saying this is the case across the board for firms that have gone down this route, but the most common ones tend to be those that have a succession issue. If you look at the first few that entered the legal market, they were generally small firms, and they were generally small firms with a very large amount of CFA WIP. So in other words, WIP that wasn't recognised on the balance sheet, and the owners wanted to get some value for, but because of the huge value of it, they couldn't attract incoming partners for the reasons we just talked about earlier in terms of having too high a barrier. So an EOT actually enables them to sell on their business. There's some tax benefits clearly in all of this, but it enables them to sell it on, get succession, and get their money out. So that I would say, yes, they could well be attractive for some of the sole practitioner and limited companies, sole shareholder limited companies out there as a route to exit. I think the other comment I would make, and I've seen, and again, it wouldn't be in the extreme cases that Viv mentioned, but you do see sole practitioners who, let's say you've got a sole practitioner who is reasonably profitable, okay, so middle of the range sort of performance. In my experience, they still have a lot of difficulty finding succession. And the reason for that is if they come along and talk to a larger firm, let's say they talk to a 10 or 20 partner firm, and that 10 or 20 partner firm picks up the phone to someone like me who's quite miserable most days, and they say, we're thinking about this company, what do you think, Andrew? I'm going to say to them, it's not worth it. The runoff risk and the impact it could have on your PII policy for the upside you're getting of bolting on a fractional increase in your turnover, it's unlikely to be worth the hassle and the risk. And that's really the starting point that a lot of the larger firms will look at if they're bolting on something really small. Is it worth it at all? So when you're then talking to the sole practitioner limited company who's trying to exit, actually one thing you can talk to them about and try to get them to put on the table is, well, is there a route of buying out the runoff cover and not becoming successor practice? And I've certainly done that a few times on transactions I've been involved in. And sometimes it can be that actually the firm that's being acquired is profitable enough for the acquiring firm to say, we'll pay the runoff cover, we'll buy the runoff cover, we won't become successor practice. And that enables us to be confident enough, we'll take you on because we can see enough upside if that risk is mitigated. Of course, the other end of the spectrum would, of course, be they have to buy their own runoff cover before they go in. But there's obviously a halfway house as well. So I'd say that's worth people thinking about in terms of structure. You've obviously got to take advice PII wise, and there are circumstances it's an incredibly difficult area of risk to manage to make sure that what you do is still effective. But there are some options there potentially.
Yeah. Well, if I can come to Tracy, in terms of the compliance side of this kind of thing, what are you advising your clients to do if they're thinking of hanging up their legal boots, and what should they be considering from a compliance kind of perspective?
Is very much, Sean, planning in advance, because I think a successful disposal is going to be your legacy to the profession. Whereas if you do it unsuccessfully, which normally happens when it's too rushed, well, all you've got then is a backpack of hassle that you're carrying around with you, because from a regulatory perspective, there will still be questions that need to be answered. If you have not managed any succession or merger successfully, then that's a lot of ongoing residual hassle for you. So it's very much getting your house in order before you've actually made the next step. And that would include things like presenting your firm in the best way possible. If you're thinking about it being acquired, that would involve making sure that you present an accurate record, accurate picture of your practice and its viability to anybody who wants to acquire it. It also, I think, and very importantly, means getting rid of the dead wood as quickly as possible before the point in time in which you cease to exist. Because one of the biggest ongoing hassles is all that storage that you need to do, that continual maintenance of old matters and residual client matters that don't end with the end of your career.
I smiled because when you said dead wood, I automatically thought of people, but you weren't talking about people there. You were talking about the admin and the okay.
The admin, because the regulator will expect you to be demonstrating compliance with regulatory standards and professional standards even after you are, in your own mind, retired. And if you have that dead wood, then you have professional responsibilities still. So I think preparing for disposal, it's getting your house in order earlier rather than later. Don't leave it till the last minute. Most people on this call will have a lot of historic files collecting dust. They'll also have a lot of wills. And I know we've got a question. Would you like me to
Yeah, sure.
That now? Because someone's asked, do you need your client's consent to sell a will bank? And that's one of the big assets I know that a lot of people in this position have to attract other people. And there are regulatory issues to all of this. If you're hoping to sell your will bank to a successor practice, then I think we're fine. We look at the will, we look and see who are the executors. If you've got professional executors, hopefully the wording is partners in the practice or any successor practice. And then we just notify the clients who are affected of the change. Where you haven't got that, or there is no succession, then as part of your admin, you as the closing down firm must contact your clients for whom you are holding their wills and let them know what's happening. Do they actually want the will to be sold or to be transferred? They don't need to know all the details of the sale, to be transferred to another practice, or have they got their own idea about what happens next? I think if there isn't client involvement in that information, then there'll be regulatory issues to consider going forward. The regulator will say you haven't thought about your clients and you haven't taken their instructions, and that's you're bad.
I know that in terms of the approach that I know some of my clients take is to jointly write to the will owner and say, hello, I'm retiring and this person is now taking over. So they get a joint letter. And then I was shocked that, and I think it was on the Law Society Gazette website, it was the Gazette website. I think there was an old article about disposing of will banks, and people saying, "Oh no, I didn't bother. I didn't bother with any of that." And you think, well, how do people know where to go and get mum's will or something like that, where you don't know? But okay, so we've got to get our act together. We've got to sort out the dead wood, i.e., the housekeeping, the filing, and all of that kind of stuff. Presumably, Andrew, in terms of the financial aspects of, preparing to dispose of your business, you want to try and create apple pie order accounts, getting rid of your old whip and all of that kind of stuff, so somebody knows what they might be taking on? Are there any tips that people thinking of disposing should do to try and keep people like you happy, as far as you've ever been happy in your life? I know, but yeah.
I could come up with a whole list of good financial disciplines, which obviously are good to employ. I mean, I think the one thing I would say when you're looking at a prospective merger or a prospective bolt-on, it gives the acquirer a lot of confidence if you're reporting some stability in your financials. So very erratic, volatile ups and downs are not greatly appealing to anyone. Actually, some steady PEP results, some steady net profit results, consistent lockup management year to year, some of that sort of stuff is quite reassuring. I think, again, if back to the timing issue, if you're thinking about this properly in advance, you'll start to think about things about like what your balance sheet looks like and what you're doing. And if I just pick up the most obvious one to talk about, the starting point on valuation of WIP for most law firms is let's keep it as low as we can for as long as possible because it defers paying the tax, which is entirely true, and I understand the logic of that. Of course, in the meantime, you're understating your profits. So when someone's looking at your business, they have no idea what the value is of WIP off balance sheet that you've decided to exclude. And of course, if you think about it a bit deeper, if you've got partners joining, you are giving that WIP away as well. So whilst I'm not wanting to spoil anyone's fun and make them pay more tax earlier, there are other dynamics to think about in terms of getting your valuation of WIP correct. So trying to argue, if you're merging in with another firm and you're trying to argue a better profit share deal with them, and you're looking at a set of accounts that show a lower PEP than them, if that could have been higher because you value your WIP on a more sensible commercial basis, you might want to think about that and accept you've got to pay some tax a bit earlier than you would have otherwise done. So just thinking ahead and thinking about some of those discussions you might have. I mean, it depends how you're exiting, doesn't it, Sean? A merger is different to a sale and a shutdown, etc., etc. So I think you've got to have a bit of a plan as to what your route is, first of all, and then think about what impact that's going to have on your accounts in the meantime.
Yeah. Okay. So getting advice early is important. Jenny, can I come to you in terms of the PI side of things and what you ideally would encourage people exiting the market to think about doing? Because I imagine most people's relationship with their broker is, oh, I've got a letter, it's about September time, I better talk to them, and they don't actually communicate with you much throughout the year. Or am I being unfair? I don't know.
It really depends on the firm. A number of firms are engaged with us, throughout the year, which is, is what we like. But yeah, sometimes other firms, tend to leave it until the 15th of September or the 28th of September, which is not at all ideal. And I think that that's one of the issues that is coming through this afternoon, and it applies to professional indemnity insurance as well. Firstly, taking advice, and secondly, not leaving it until the last minute. And if the firm is in a situation where they're looking at needing or wanting to close, it's really important to engage with their broker as early as possible on that issue. And it's always important to remember that your broker's on your side, and it depends too. If you're simply looking at a situation where you don't believe there are any options and you're just looking to close the business down, then it's important that you understand as early as possible, what your runoff obligation is going to be, and that's usually spelled out in the policy documents. But your broker can help you to understand and be certain about what that is. If you're looking at a scenario where all or part of your practice is going to be acquired, then it's really important to start considering early on what the successor practice rules might say about that, because the successor practice rules are quite complex and they're very fact specific. And sometimes they may result in a situation that is unexpected. certainly quite often for an acquiring firm over the years, I certainly have seen situations where firms have not anticipated that they were becoming the successor practice with the obligation for responding to PI for claims against the firm that has now ceased. So there have been, scenarios where after the event, because it hasn't been considered properly at the time, because advice hasn't been taken, successor firms can unwittingly find themselves in a situation with that responsibility. So it's important in that situation for the firm that's being acquired to take advice and talk to their broker about what the situation is, and for the firm that is acquiring the practice to likewise talk with their broker, because sometimes when it comes to PI, a merger or acquisition, the PI can scupper the whole situation. For example, and Andrew has touched on this, if an acquiring firm goes along to their broker, talks to the insurer to say, what's my additional premium going to be if we become a successor to this practice? And it may be that the increase in the PI is going to be cost prohibitive, that the deal's not going to be worth it. Or again, I've seen scenarios where the insurer says, really unhappy about you acquiring that firm, we'll have to review the position at renewal if you do so. So it's really important to tackle this issue head on. If you're the firm that's being acquired, you're the firm that wants to hang up your boots, it's important to understand, if you're looking at the successor practice model, that the firm that's looking to acquire you will want to talk to their broker about the situation. The insurer will want to look at your last proposal form. You will need to get them an up-to-date claims history. So there's quite a lot of work that needs to be done around that. And the earlier that's done, the better, because if it is a showstopper, you don't want a situation where you've put an awful lot of time, effort, and energy into the situation, only to see it fall over. Just a word too on the elective runoff, which is something that Andrew likewise touched on. Elective runoff we do see happening, quite often, where an acquiring firm says, well, we don't want to become the successor, but if you take elective runoff, which means that the acquiring firm isn't responsible for your PI claims going forward. There are some rules around that elective runoff. You have to make the election before your firm closes, and most importantly, the premium has to be paid. Sometimes it depends on the policy, the runoff premium, the cost of that is spelt out in the policy wording. There are one or two policies, insurers around that say, well, we'll decide if and when you come and ask that question of us. But it's absolutely critical for that election to work. The premium must be paid prior to the succession actually happening and your firm closing its doors. It's also really important to understand what happens at the end of that 6-year period. Because there is a bit of a myth out there that at the end of the 6 years, the successor practice again picks up responsibility for the claims. That's actually not the way the rules work. And this is where the whole SIROC issue, post 6-year runoff cover, that is very much in the headlines at the moment, comes into play. Because if you are the firm that's closing, in 6 years' time, when your runoff comes to an end, what's your protection going to be? Now, at the moment, we've got post 6-year runoff cover that's being continued until the 30th of September next year. There's a huge, obviously, debate going on about this with the SRA, who've accepted that there's not going to be a suitable market solution for this. We need to keep a watch on this issue, because hopefully we'll either get a continuation of SIROC under SIF, or we'll get compensation fund picking this up. But again, it's another issue that firms that are closing need to put on their agenda of things to consider what the protection is going to be at the end of that 6 years.
And Jen, how long would it take to, to sort some of these indemnity insurance queries out? Because that it doesn't sound like it's a quick process to me.
Yeah, it really depends. It can get, very complicated. What I would say is that you want to avoid a scenario where you decide, a week prior to your renewal that you're going to look at a succession arrangement and are trying to do all of this, because it does take time. Some scenarios are, very simple. If it's a firm that's really wanting to make the acquisition, and you've got a good practice with an exceptional claims record, and they're comfortable to become the successor practice, and their insurer is comfortable with that, it can be very smooth. In other scenarios, the whole arrangement can fall to pieces simply because of the PI position. So again, that's why getting a very early view on how that's going to play out is important.
Okay, all right. Now, before I finish with you, I want you to tell me what's going on in the market, because I imagine there's a lot of people listening to this that are thinking, I've had my renewal, or maybe I haven't opened the envelope yet. I'd rather not. But you probably send PDFs these days. But what's going on in the insurance market? Because it's at that time of year which I know lots of lawyers dread.
Yeah, no, absolutely. It's been a tough few years. It really has. The hard market, has not been easy, and premiums have continued to go up and up. As far as 2022 is concerned, because obviously we've got at the moment the benefit of having had the 1st April renewal, and on the harden book, which is large enough to be reasonably representative of the entire profession, 30% of our book renew on that date. So that's a good bunch of firms to give us a view of where we're at, and we are seeing the same pattern repeated in the quotes that are coming through from 1st of October, which are that we are still in the hard market, but there is what we're calling a glimmer of light at the end of what has been a very long tunnel. We're still in the tunnel, but we are seeing a flattening of the curve, in that the increases that we're seeing are not as steep as what we've seen over the last 3 years or so. We are also seeing insurers with a bit more appetite for looking at new business, certainly more interest than we've seen in the last 3 years. But of course, their interest primarily relates to firms that they perceive to be a good risk because of their work split, claims record, etc. So it varies, of course, from firm to firm and insurer to insurer. Those firms that have got the better claims experience are obviously going to fare better and are faring better in terms of increases, and likewise the work split. Insurers are still very nervous about conveyancing, and that relates to the SDLT holiday, and they're concerned about the pressure that fee earners were working under and the potential for claims. And quite important as well, where we're going in terms of the economy and the property market. Nervousness around that, because history tells them that when there's an issue with the property market, that generates more claims against solicitors. So mixed picture, but broadly, we are seeing, as I said, less steep increases than we have seen. Looking ahead to next year, there's discussion in the market about potentially a new insurer coming in. That was in legal futures today. We'll just need to wait and see whether that happens. But we as a broker have been saying, what will change and move this market on is if we get new capacity into it. However, a word of caution on that, while we will get through the hard market, we will come through to the other side. The profession can't expect that premiums are going to return to pre-hard market levels, because this has been part market correction as well. And if you look at the historic stats and the claims figures, you will see just how bleak that claims picture has been in prior years. So some of this change had to happen. But as I said, we will get through it, but it will not go back to pre-hard market levels.
Great. Oh, blimey, I'm pleased I got you and Andrew sitting next to each other in the happiness corner there. And just before we...
As you mentioned that, I was just going to pick up on actually a couple of points now.
Yeah.
In terms of relation, and it'd be interesting to know what Jenny sort of comments on this as well. I appreciate on the call there might be some people looking to sell and also possibly some people looking to buy. So I think this comment's relevant for both camps. If I ever get a call, one of those calls from a 10, 15 partner firm bolting on a 2-partner firm or similar sort of ratios, and they say to me, what do we need to do on due diligence, Andrew, on financials? My slightly flippant initial comment is you probably don't need to worry about the financials too much. We can do some stuff on that. The thing you really need to be worried about is doing file reviews to actually get a view as the quality of the legal work they undertake. And the next statement the managing partner quite often makes to me is, oh no, we've done that, Andrew. They've had a really good claims record. There's no problems there. And I think I then go into a sort of a diatribe, which Sean may have heard before, which is just because they haven't had any claims in the past doesn't mean they haven't got a load waiting. And secondly, in 5 years' time, if you're a 20 million turnover firm with a load of claims that emerge from a 1 million turnover firm you bolted on, the insurer is not going to favourably look at you and say, don't worry about it, it's only that small firm. They're going to look at a 20 million turnover firm with a big claims problem. And so at that point, you've potentially got a financially crippling PII policy. And yeah, returning to the point about having a good claims record, a lot of the time, my comment is send your best people in to do those client file reviews and pick the fee earners that were there for 6 months and left, not the ones that have been there 20 years, because the problems are likely, you need to risk profile the work you do. So so there's lessons here, I think, for a firm that's trying to sell their business in terms of those are the things a purchaser would look at, and vice versa for an acquiring firm. So I don't know if Jenny's got any other comments on that, but I find it's not an area I know a lot about technically, but from a practical point of view, it's where the biggest risk lies really for both a buyer and seller.
Yeah, absolutely. I've seen those scenarios where a firm becomes a successor, thinking that it's a squeaky clean firm, and then 6 months, 12 months later, there's a huge raft of claims that come out of the woodwork. There is, due diligence is important, but I'm actually, I think, going to refer that issue to Tracy to if we can have her view on that at the moment, because again, there's this whole issue of client confidentiality, which becomes a problem in that. From an underwriting perspective, it's really important to look at the claims history as well. And for example, often firms, say, we've got a lot of notifications on our claims record. Firms that make precautionary notifications that move to close no pay from an underwriting perspective are very much a more positive thing, because in that scenario that risk management is alive and well within the firm, and that the solicitors and the fee earners are comfortable about highlighting concerns that they have, and matters get notified. Sometimes where you see a firm that's a certain size and they've got absolutely no notifications at all on their claims record, that's actually potentially a red flag, because there should be things there that people are concerned about, that they're notifying. So, you know, again, it does come down to due diligence. It does come down to, you know, understanding the practice, you know, what its approach to risk management is, understanding what its culture is. And as for the file review issue, if Tracy, I'm really perhaps think it would be great to have your comments on that.
I'm gonna come to Tracy in a minute, because I know the questions, all of the questions in the Q&A are all Tracy at the moment. Be a good chance to plug your book in a second, Tracy. But just before we leave the happiness corner, as I've called you and Andrew, Andrew, you were mentioning about Q1 next year and how you thought that was going to be a grim time for lawyers. So I just thought, while we're all so upbeat at the moment, do you want to talk us through why Q1? We already know that, you know, April next year, you know, that's when some firms are going to renew their insurance. But Q1 next year, I know you've got a take on that.
I have, but I mean, to give some yin and yang, I mean, law firms have had the best 24 months I've seen in 25 years. Yeah, the results and what they achieved during lockdown was absolutely phenomenal. You know, I spent most of last summer going to law firms saying to them, this is a totally exceptional year. You'll never see anything like this again. And I have to say, this summer, it's not been far off last summer, to be honest with you. It's been another really strong year. It hasn't quite got there compared to 21, but, you know, it's been a terrifically strong period. If as always, I can turn a good news story into a bad news one. Obviously, at some point, tax bills get paid on those stunning years. And there are, unfortunately, quite a few firms out there who were in, should we say, financial strain before lockdown started. But ironically, because of the financial support that was available, because of the just totally buoyant property, private client and family markets, you know, the mainstream of an awful lot of these firms, they've actually managed to hobble on reasonably well, even though perhaps under normal circumstances, other things would have happened. The difficulty, however, is going to start to come when the CBILS loan repayments start to bite, when the income tax bills from April 2021, you know, the final instalment comes through in Jan 23. You know, it seems certain that energy bills are going to go up, and, you know, whilst we're not manufacturers, we still heat offices, which I suspect people will use a lot more this year. And, you know, we're also, it seems probable there will be some sort of downturn in economic activity. So all of those things point towards Q1 of 2023 not being the happiest time for a lot of law firms. So, yeah, depending on whether you view this as an opportunity or a threat, yeah, there could be some firms around that are looking for immediate succession in sort of February, March, April time next year. And yeah, I genuinely mean that may well be some opportunity for some firms. It is a good time. You know, we all know resources in terms of people are extremely difficult. That may well be a good time to take some action there. But I'd see next Q1 next year being quite critical.
Right. Oh, great. Okay, right. Tracy, I'm going to come to you because would you just like to tell the good viewers about this book that you've written for the Law Society? Because it's got a very snappy title, which may help some of the questions we've got. Give yourself a plug.
Thank you, Sean. Yes, I have just published a book with a co-author, Risk and Compliance, Questions and Answers. It's meant to be a dip in and dip out book, giving you the answers to all the questions you never even knew you needed to know. So that was
and of these questions that we've got coming in our Q&A, are some of those answered in the book?
They are, thank you. At least I was on the right page.
Fantastic. Well, that's wonderful, because we will deal with some of those later on. But what I'd like to ask you is, Tracy, okay, look, we've reached the decision. We've got to do something about our business. We're going to make the decision. We're going to shut down and get rid of it. We've got to get in touch with the SRA. I know certain people regard the SRA as the bane of their lives. Other people, you know, more proactive about a relationship with the SRA. What is it you've got to do when this happens? Okay.
So you want me to make everyone feel happier about the SRA now?
Well, on the back of that, Andrew's gloom and doom, yeah, this is where the SRA might actually come out more positive.
Yeah. So to be frank, For many people on this call, they will find the SRA very different to the regulatory body with whom they started their career, because that was the Law Society. And the Law Society was a bit softer, a bit fluffier, a bit more helpful towards the profession, by which I mean they provided membership services as well as everything else. Now we have the Solicitors Regulation Authority that is purely regulating us to protect clients. So their interest in us is very different to what the Law Society's interest was. And their interest in how we run our businesses is far more critical than the Law Society's view ever was. And they have a regulatory requirement on all law firms, whether they are sole practitioners or bigger firms, saying that you must at all times actively monitor your financial stability, your business viability, and once you're aware that you will cease to operate for whatever reason, you've got to effect an orderly wind down. So your question, which I know you're going to ask us right at the end, of how long does this take? I'm going to suggest the longer it takes you, the more orderly the wind down will be, and the better the relationship with the SRA will be. They expect to be notified in advance of your decision that you are going to close down. And they have even provided you with a firm closure notification form to give them all the relevant details, and that's on their website. They expect you to be thinking about residual duties to your clients. The big thing that I've already hinted at is the storage of documents. And someone's already said, what happens if you can't dispose of everything? Do you continue to be a practice? Well, no, you don't continue to be an authorized practice, but you personally, as the keeper of all those documents, have a professional responsibility to keep them safe and to tell the SRA where those documents are, so that if clients looking for an old will or whatever can't find you or your practice, they can go to the SRA, and the SRA can say, well, they have been handed over to this firm, or they're being stored at this address, or whatever. So it's important that you're open with the SRA about all that documentation, which is why, as part of your housekeeping, you will want to dispose of as much of that deadwood as possible, which you can do by simply returning documentation to your clients, or by finding a safe home. If that's not a successor practice or a merged practice, just another safe home for that documentation. Which leads on to the confidentiality issues, which Jenny gave me. Thank you, Jenny. Confidentiality, it's a residual duty which we owe current and former clients, however long ago they were former clients. Of course, that means there are practical issues, because we want to hand over files to another firm. They'll then get access to our confidential information. Or we might be wanting to sell our business or merge with another firm, and they want to know about our files and our client base. Well, there we have to have a bit of common sense and think, well, we're talking with other regulated individuals. We need to have some sort of agreement about the use of that confidential information, which is going to purely be for the due diligence purposes, because a client can come back to us if they feel that we've breached their confidentiality, however long ago we did that. The worst scenario I've heard of that, the worst scary anecdote, is a solicitor in 2016 who was disciplined by the SRA because they found out that he'd breached confidentiality, not in 2016, but way back in 1978, I think it was. And they found out all those years later, and they still disciplined him for that. So this is a scary duty, I think, this confidentiality duty. Other scary things, undertakings. Just because we stop being in practice, just because our circumstances change, we can't bin the undertakings that are live. So we need to do due diligence on that. The only person who can release us from an undertaking is the person who's relying on it. And if we breach an undertaking, then in some cases, not all, but in some cases, there can be court action. In all cases, it's seen as misconduct, and the SRA treats a breached undertaking as one of the more serious things. So we want to be doing due diligence and all of that. What undertakings are live and what are we going to do about that? We also need to think about the records that need to be retained, records for regulatory purposes. There's a very small part in the financial services rules that say you must keep records of those, and I often find they're overlooked, but we have a regulatory duty to do that. We have a regulatory duty in respect of our money laundering checks. We have all the record keeping that Andrew and Viv will know more about in terms of tax returns and all of that kind of stuff that we still need to keep. We need to think about data protection issues. We need to inform the Information Commissioner's Office that what's happening with the data for which we have assumed responsibility as data controller, is that changing? And that needs to be part of the agreement. And there's an awful lot of things that need to be ticked off in order to get over to the other side of this journey, still in a fuss-free relationship with the SRA, because they will be interested in you long after you're interested in them. And the other thing I'd throw into the mix, if we're talking about regulation and compliance and professionalism, is we have, of course, a principle that you act with honesty. And a number of the SRA's enforcement projects and the work that they do in that area is not just about honesty in respect of client money or honesty in respect of how we treat clients. It's honesty in how we treat other professionals. And solicitors have been disciplined most severely because they have been dishonest in how they present themselves and their business to other professionals. So you need to be really, really careful about what you're saying about your business, should that be a business that you want to offload onto somebody else. Does that make you happier or not?
Well, I think you need to go sit with Andrew and Tracy there, but yeah, we've got one question here actually. It says the SRA says we have to inform them about our closure as soon as possible, but the form says not more than 7 days before closure. What is the solution? Is it, you know what, just 7 days notice? Well, that can't be right, can it?
No, I don't think so. I think that would be my stop point. I think I'd want to be bothering them a lot earlier because we also have these regulatory duties to be open, transparent, accountable. And I think particularly if we are closing down in unexpected or upsetting circumstances, such as, oh, we've run out of money or the tax bill's too much, we can't pay to open the office, the earlier the better. Not because they're going to come in and help with finances, because they won't, but because then they can start talking to us about, okay, what are you doing with your clients? Which is another point as well. Orderly closure, the earlier you start thinking about it, the better it is, because you don't want to be taking on new clients 7 days before closure, because that's no good for anybody really, is it? You need to be winding down in that way as well.
Yeah, okay. Right, and when the SRA get these forms, they get these notifications, what physically happens at SRA headquarters? What do they do? What do they pick up the phone and say, Sean, what's going on, or what?
Well, I think it all depends on how well you've completed the paperwork, to be honest,
right,
and how risky your circumstances are. Now, if it's a huge practice and you are one of the main legal services providers in a particular area, maybe you are the main service provider for a particular type of service. I'm thinking in my head, maybe you've got a legal aid contract or something like that, and your demise will have a huge impact on clients and access to justice, then maybe they will be picking up the phone and having more conversations with you. If they can see that it is an orderly closure, they can see that there are no risks to clients, I don't think you're going to have that much contact from them. What they will be doing at that time is just the process of deauthorizing your law firm. And of course,
Right.
once the law firm is deauthorized, you can't hold it out as a viable business anymore. It's no longer a law firm. It's no longer able to provide legal services.
Okay. Right. Well, I'd like to come back to Andrew if I could. And Andrew, from the accounting point of view, I gather that, you know, when the firms are shutting down, they need an accountant's report. They've got to make sure that they haven't got any client money, residual balances, all that kind of stuff. What are some of the headlines things from an accounting perspective that people need to think about when they're hanging up their boots?
Well, I guess there's primarily two sides to it. The regulatory side in terms of client money, and the accounting and tax requirements side in terms of the business. I mean, in terms of the latter, it's going to depend what trading structure you're in, but you know, in most scenarios, you will be looking at cessation accounts potentially, and it may well be that your law firm business actually carries on as a trading entity, ironically, for some time after you stop being legally regulated. So if I give you an example, Sean, quite a common structure for, let's say, the disposal of a traditional LLP or partnership business into another would be that actually the ownership of the WIP and debtors doesn't transfer to the acquiring firm. And effectively the acquiring firm is just collecting them on your behalf. So if you follow that through for a number of years, potentially post cessation, if you like, you potentially have monies coming in or not coming in, expenses in terms of forms of bad debt, or additional income in terms of form of WIP, which wasn't originally recognised. So they could go on technically being active from a financial point of view for a number of years, but at some point there will come a stage where, you know, all monies have been collected, all balances paid out, and you know, you're looking at shutdown. So you know, your responsibilities in terms of preparing accounts, dealing with tax could carry on for some time, but eventually they come to a halt. And that's going to be broadly the same, whatever sort of structure you go into. I mean, one thing, there's quite a lot of sole practitioners, I think, on the call. So I would imagine we have quite a lot of limited companies potentially, because that tends to be a vehicle of choice for the smallest of firms. Of course, for a lot of those, they've been set up as pension funds effectively for the owners. So rather than stripping out all of their profits over the years, they've left some of it behind. Those sort of firms will have a decision to make. So they may well be looking at liquidating the company in some form to take advantage of business asset disposal relief. They may be looking at a repurchase of shares for similar reasons. Or alternatively, they might be looking to just keep the company sat there drip feeding cash out to them over a number of years. And of course, one of the things they may want to consider if they're going down that route, of course, and even if they're looking at disposal, liquidation, is once they are no longer SRA registered, there is of course no rules around who can own those businesses. So that's the sort of time when they start to look at spouses, civil partners, people they like a lot, and start to share some of the past profits with them potentially. So there's definitely some tax planning considerations around that part of the equation. On the client money side of things, in most scenarios, if there's an acquiring firm, the client account balances are all transferred across with a list of matters that hopefully tie up to the same amount, and the client account is closed. And you have a final report that's usually prepared. There are certain circumstances where you can avoid a final accountant's report, but you know, it just depends on the precise mechanics of the deal you've got in place. But there either will be or won't need to be a final client's report, and that will be it effectively.
Okay, got an interesting question from Gillian, and she's actually said, is it better as a sole practitioner currently operating as a sole trader to change to a limited company in preparation for a sale or merger in 2 to 5 years, or doesn't it matter? Is there any advantage being a limited company?
My initial glib response to that would be no. because it just depends on who's acquiring you. And for example, you could easily say if it's an LLP or a partnership acquiring you, it's probably more of a hassle if you're a limited company, actually. If you're being acquired by a consolidator, they probably really don't care. And if you're being acquired by a very large firm, they're just going to buy out the clients anyway. They're not going to want to take the shares. I think the biggest consideration for your trading structure is going to be who you see your future owners being. So if you ever see your future owners being primarily people who are at one stage or another employees in your business, then it's likely that a limited company is not a good idea. If you're a very profitable business and there's only one or two owners, then limited companies are great because they give you the opportunity to leave the money behind, warehouse it, pay less tax, and then stand a sporting chance of getting it out in the future at a lower tax rate. So hence why I said on this call, if we've got lots of sole practitioners, it's probably more likely to be an appropriate vehicle for you, but from a longer term tax planning point of view, rather than anything to do with a transaction you're going to go through. If I went back 5 or 10 years, probably 10 years actually, closer to when the Legal Services Act came in, if you talk to any equity house or any angel investor, being a little bit tongue-in-cheek and glib, they didn't really understand partnerships or LLPs, so they always said, oh, we won't do anything unless it's a company. And I think some of that sort of thought process is gone now. The world has sort of woken up a bit more to professional partnerships, I think, in that context. So very long waffly way of saying no, I think.
Okay, just probably one for Jenny now. Really, I've got a couple of questions about the cessation period of 3 months. So, just want to talk us through the cessation period, how it works, and then what people can and can't do. Because what somebody has asked a question: could we try and sell our business during the cessation period and not renew our cover?
Yeah, the way that it works is that if you don't renew on due date, there's a initial extended policy period. First period is 30 days, during which time you can continue to practice as usual while you still try and find your PI. If you manage to get PI cover during that 30 days, it must be backdated to the date that your last policy expired. If you haven't managed to get insurance cover during that 30 days, you then go into the 60-day cessation period, during which time the expectation is that you will conduct an orderly closure of your business. But again, it can, in some instances, be possible to actually get your PI during that 60-day period, which is fine, again, provided it is backdated to the expiry of your last policy. You can't take on any new clients during the 60-day cessation period. And the whole point is that you're moving towards an orderly closure, but also it does, give you some time to potentially enter into negotiations with another firm who may or be interested in acquiring your business or acquiring the will bank or working with you in some way.
So that's interesting about the not taking on any new work. So as from the 1st of October, then I'm not insured. I'm talking to somebody about possibly doing a merger with them or a deal. I can't take on any new work.
But for the first 30 days, you can.
I can.
At
Okay.
the end of that 30 days for the next 60-day period where you're not able to take on any new clients. Yeah.
Right.
But
Okay.
for the first 30 days, I mean, it's quite useful because it does enable you to continue on a business as usual basis while you try and shore up the position. But one of the difficulties is, because the cover has to be backdated to the 1st of October, if you have a big claim that comes in notification on, the 3rd or 4th of October, that's going to be a real problem. So that's why we say to people, don't rely on that cessation period. A lot of people think, oh, it's sort of, that buys me a bit more time to sort this out because I've left it a little bit late this year. you certainly do not want to be in that situation. It is very, very much a backstop and should be treated that way.
Speak to your broker early, I think you're saying, Jenny. Okay. All right, Gang, just looking at some of the other points that I fired at you when we were planning this. Dealing with staff and making people redundant. Any experience of dealing with that? I know that if you're effectively, in inverted commas, insolvent, then people can make a claim against the state. But is it really just a question of, well, hopefully, if you've got good people, they're going to find jobs elsewhere anyway. There seems to be a battle for talent out there. But redundancy, anybody got any take on that? Going to take that as a no then. So well, there we are. I should have had an employment lawyer on this one, but I'll talk to you about another event coming up later on. And then clients, I think we've done a lot with clients with Tracy. In terms of just the communications with clients. If somebody's shutting down, fine if you've got a will. Mm-hmm. Hello, we've got your will. But just because we did your conveyancing 2 years ago, presumably I haven't got a right to you and say I'm shutting down. If I've got any money on client account, for whatever reason, yeah, I've got to do something about that. But it's just really if you're holding clients' papers and property and wills. Is that in a nutshell?
In a nutshell, yes. And also, of course, clients where you are currently acting on transactions. With the point that you need to be giving clients the right information so that they can make an informed decision as to next steps.
Yeah. And this is probably one for you, Viv, in terms of work in progress. And, when you're offload, you've got a firm that's got files, they're breaking up the assets of the business and finding homes for people. What are some of the war stories that you come across on dealing with that? So I know there are people out there, again, who buy litigation whip, don't they? They buy files that they like, litigation files, and there are people who find homes for those.
Well, the last thing we want to see is an intervention. So if there is an insolvency practitioner involved, they will look for homes for the various bits of business and break it up. But I think one of the things that I wanted to observe is that I know we're talking about closure and hanging your boots up, but I've never seen more activity in terms of consolidation and merger than we're seeing in the marketplace currently. There are loads and loads of consolidators out there prepared to acquire all sorts of firms. So don't think it's just doom and gloom about closure. I think there are opportunities in the right circumstances to find an acquirer, however way we get round it, but there are loads and loads of opportunities. I've never seen the market so active. And I think in the last couple of years, what we've seen, as Andrew pointed out, we've seen a very active legal market that's come through the pandemic exceptionally well. But what we're seeing now is people realizing that in March 2020, they had a succession crisis, whether they were a sole practitioner or a smallish firm. They've still got one today. It's not gone away. So by now looking actively and saying, what can I do to actually find a solution to my succession issue or exit planning? There are buyers out there currently that would be more than willing to take on many of the firms that are probably listening to this call today. So I think what we're seeing is a gradual move towards what's happened with private equity. And I'm not going to talk about flotation in any depth, but we are seeing, as we know, firms floating on stock markets. But the amount of interest from private equity is huge. And that doesn't have to be an American house coming in buying a top 100 law firm. I have got financial services practices, for example, buying law firms because they can see the value in developing a private client service which feeds financial services. So there are more and more opportunities than perhaps we think. And although if we do it properly, following the guidelines that we've laid down today, I think you'd be astonished by the amount of interest there could well be in practices that think they need to close. The thing is planning for it early and getting ready for it.
Yeah, I think it was interesting when we were having a chat before we started this, that you and Andrew were talking about the numbers in the profession and how the headline numbers of firms isn't dropping. It's just a bit different. The makeup is different.
Yeah, I think that's a good point, Sean. I was just going to pitch in and say I wholeheartedly agree with everything Viv has said there. If if I think back a few years, so I act for about 120 firms of really wide-ranging sizes. If I think back a few years, it was very, very rare that I had a conversation with a client about a third-party purchase. So someone outside of the legal sector, a consolidator or such like. I reckon on average once a month I have a conversation about a new approach that's looking like a serious contender, which is, you know, that's a massive difference, and there is still massive amounts of interest out there. And I think in a way what we're saying today is that maybe for a lot of the firms that are on this call, the traditional succession route is not as open to them as it used to be, but there are, as Viv said, a lot more options than there were 5-10 years ago for those firms. I think the point you were making about the composition of the sector there, Sean, is again perhaps relevant to the audience on this call, which is some statistics from the Gazette which were released last summer, where they made comments about changes in the composition of the sector, and they said there had been a dramatic drop in the number of sole practitioners, and there had been a dramatic rise in the number of limited companies that were trading. And I forget the exact story behind it, but it was statistically correct, but perhaps missed an important nuance in terms of what's happening. And that certainly what I'm seeing these days is there are a lot less people willing to be or setting up or taking on sole practitioners or very small law firms. Their structure of choice tends to be these consultancy models in whatever form, and because of the way they're structured, they require people usually to set up as a limited company. So almost in one sentence we've explained why those, you know, amazing statistics are taking place, and it's just, you know, it emphasizes, you know, why some of the people which are in small firms are finding it difficult to get natural succession, I think.
Right.
And don't forget, there's still a number of firms that are actually offering non-reserved activities, which are not regulated, and that's a real growing trend.
Expand on that, Viv.
Well, if you're practicing law but a non-reserved activity, there is no actively. You don't have to be regulated by the SRA, I believe, Tracy.
In certain, yeah, for non-reserved, yeah. There are certain
Employment, for example.
Yeah. There's obviously the development of freelance solicitors now who don't need to be in the same sort of relationship as the traditional law firm, so that there are a lot more opportunities now.
Yeah,
it's just another option.
Yeah.
Okay, folks, I will just canter down some of the questions. Tracy, I hope you've been keeping an eye on these questions coming through, because I tell you, your book is good. The sales are going to go through the roof, I would think. I would heartily endorse you to get a copy of Tracy's book. But we've got lots of questions about the cessation period as well, about runoff cover. We have to pay the runoff cover from the point when do we have to pay the runoff cover? From the point when our existing insurance has expired, or can we wait until the last day in December? Well, Jenny, you'd probably say it doesn't make any odds because it's backdated anyway.
That's right, it is backdated. I mean, take a look at what's in your policy documents on this. Talk to your broker. Yeah.
Okay. Somebody's saying here, what happens if you can't afford to pay the runoff?
Yeah, well, the bottom line is that qualifying insurer has to provide the runoff cover, whether they are paid for it or not, which is why insurers are looking at firm finances so carefully, because they don't like being left with a bad debt and having to provide 6 years of runoff cover. There are provisions in the participating insurers agreement that result in insurers providing information regarding non-payment to the SRA. Obviously, if you are in a partnership or sole practitioner's personal liability, and a number of the policies, even if you're in a corporate structure, say that an individual who is a member or director or is held out as a principal will have a liability for any premiums. So bottom line is that the insurance cover will be there, but there are potential consequences, obviously, from for non-payment.
Okay, so somebody's going to come after you and get their money back. There's a great question here, and for someone that I think must be compared with what Tracy was saying earlier on about the deadwood. We got this: when a practice was completely paperless, the practice was purely commercial, no wills, no deeds, etc. All our documents and records were held electronically. How would you deal with the records and documents after ceasing? Well, you just buy a CD-ROM, do you? Or
yeah.
put it on Amazon, an Amazon server somewhere.
You still need to protect it, but it's going to be a lot less complicated and probably a lot less expensive that way.
Congratulations, Kyriakos. There you go. The thoughts of barns and secure storage facilities, I should say, with all these files in them and things like that, just nightmare. I know years ago I looked at one firm and it was chatting to them about what we might do, and the costs of getting their files out of storage because they'd never shredded anything were just astronomical. And it was kind of like, oh no, don't like the look of this really, because it was just they just regard it as day-to-day overhead until all of a sudden you want to start moving them and get rid of them. But there you go. Not new clients. Trevor said, sorry, I've got to leave, but thank you very much for an informative presentation. So I think we could give ourselves a pat on the back. I will ask you folks the question that I alluded to at the beginning. So people on this call, and I'm delighted to say that we haven't had many drop off, so we've still got over 60 odd people on the call, and we're going to get people recording. How long do we think that people should prepare in advance, in either weeks, months, or years, to hang up their legal boots? Tracy, come to you first. What do you think?
So if on the day of departure you just want to lock up and sail off into the sunset, I'm going to say 12 to 18 months.
Okay. Viv?
Again, it depends on the circumstances. So if it's a straightforward merger stroke acquisition, that could be anywhere from 6 months to 12 months. But realistically, if you're going to do an organised closure or hanging their boots up, anywhere between 3 to 5 years, that should be the planning.
Yeah. Jenny, what have you come across? What's your gut feel? Oh, perhaps a logic, perhaps data proves it. It's not gut at all. Who knows?
I mean, again, my answer is it depends on what you're doing, how big your practice is, how complicated the issues are. But yeah, my gut feel is that you need to be thinking about this at least 6 months ahead of time, even for a simple closure.
Okay. And Andrew, from the accountant's point of view, if you're going to get a bang for your buck, hopefully, but whatever. You've mentioned
I may come back as a politician because I'm going to give you 3 answers. Right. Answer number 1 is my preferred route, which is you seek somebody internally to take over your business in a traditional succession. And I think you need 5 years for that. You need to identify them, get them into the role and get them ready. If you are looking to flog it, 3 years. 3 years to get your finances in good shape, get some consistent numbers on the table, and get everything in line. If you really just want to lock up and shut down, a year.
Yeah. Well, thanks for that. I can tell you that, again, I mentioned a client looking to acquire will banks. I spoke with one owner of a law firm who needs to shut down quickly. He will shut down quickly. And I said, how many wills have you got? Oh, about this number. How many of them are you executor on? Don't know. How many current probate files have you got? Don't know. What is the whip on them? Don't know. And it was on that kind of stuff where you think if you're the seller, the price is just going down and down and down. And I just think that, I think all of you give really good time estimates. And the answer is, from my point of view, it's always going to be longer than you think. Because actually, if you do want to get rid of your deadwood, you do want to present something that looks attractive, whether it's a successor practice or even looks attractive to the SRA, so that they just think, all right, we'll let you go. you know, it's going to take longer than you think. Right. Now, assuming you're all not so depressed that you don't think that, you know, you're going to just keep away from sharp objects for the rest of today, I will tell you that there is going to be another one of these Hang Up Your Boots series, and it's going to be with a guy called Mark Briegel and Bennett Briegel. Mark is a lawyer that deals specifically with professional partnerships, and he's going to be talking about the legal paperwork and the process that you're going to do if you're going to sell or merge a law firm. So hopefully that one will be a bit happier, because you know, we're not going to be so completely depressed, but we'll be talking about actually the legal hoops we've got to jump through to do that. We are 4 minutes to 5. I optimistically, I thought, oh, we'll never fill 90 minutes. I think we could probably fill another half hour if we went through all the questions that we've been digging through. But ladies and gentlemen, on your behalf, can I thank our panel for giving up their time today? I personally really enjoyed it. I've learned a lot. Tracy, I hope the book sales go well. You know, if anyone wants to mention Hang Up Your Legal Boots, I'm sure the Law Society won't give them a penny discount, but you never know. I hope that the sales go through the roof of that. Viv, thank you very much for everything that you do. I mean, you know, always interesting to hear what you're up to. Jenny, thank you. I know that at the moment, insurers is probably not flavour of the month as a profession. You're probably trying to say I'm nothing, you know, but you know, we've got to have it. You've got to have it. I'm sure you're looking after your clients in a fantastic way, and Howden's have got a great brand and lots of clients. Andrew, as always, my friend, thank you very much for everything you've had to say. Always value your wisdom and what you've got to say about the accounting world. I know you're a bit miserable. You've been telling me for years you're miserable, but you're not that bad. If I could put up with you, everybody else who, but if you do need decent accountancy advice, Andrew is a very good man to see. Lots of other accountants out there, you know, but yeah, Andrew's certainly worth having a chat with. But ladies and gentlemen, participants, thank you very much for participating. I hope you've enjoyed it. This will be available somewhere to view again at some time in the future. I will email everybody that has subscribed to this to let you know where the links are so that you can view it again in your own time, if indeed you wish to do so. But thank you very much for participating, everybody. Goodbye.